Porsha Shaf'on Venable. Here we are in the 12th month of the year with
Hey,
another jury duty unmasked. How you doing?
right. I'm holding steady.
Steady, steady and strong.
Yes.
This is exciting. It's the last month of the year, and we've been having a variety of conversations of things related to our criminal legal system, related to jury service, and really the common denominator that I've been noticing is the power of the people and being able to remind people the power, as you like to say, the power of your presence and the value of your voice
That's
in that
right.
jury deliberation room and in that jury box. This evening, we got three things we're going to be talking about as people hopefully ask us some questions. The first topic of conversation is going to be this concept of due process and what is it that we expect that to be? What are we seeing in America right now? And then what it actually is from a constitutional legal framework. And the second conversation we're going to have is about this case that's going on with James Comey, the former FBI director, and the involvement of a grand jury and a special prosecutor and some issues that are being present there. And then the third topic of conversation is going to be about the latest update with the case involving Luigi Mangione in New York. So, with that, I want to get your perspective. As people have been witnessing, customs and border patrol agents and ICE agents and federal officers, snatching people off the streets, they have been calling out for due process. And why is it that you think people are calling out for due process? What has been your, temperature read of how people are feeling in this moment as we're navigating these troubling times?
So if you think about it, right, just on a basic level, right, we have all been taught to follow process, right? In order to get to B, you have to go through A. In order to get to Z, you have to go through the other letters, right? From A, right, to Y, to get to Z, right? And so when we as people are witnessing an abrogation of those processes, it really does create an unrest, right? So you don't know how to get to B, or you don't even know if B is next, right? Because so many steps are being skipped by our government. So many steps are being skipped by those that are supposed to be the individuals that are slated to protect our rights. And it creates unrest. It really, really does. I mean, I feel anxious when I'm, looking at the TV and I'm watching individuals all across this country be snatched up. It's terrifying, just even as an attorney, right? Watching what's happening in our courthouses. But I love, love, love that despite the fact that our government officials and officers are ignoring process, the people are speaking out all the time. Judges, are growing a pair, and they are doing the right thing, right? They are reminding us that even if those above us, right, don't want to um acknowledge that there is process, acknowledge that there is procedure, they will. Thank goodness for checks and balances. Shout out to my sixth grade teacher.
I'm gonna shout out Schoolhouse Rock as well.
That's right.
The thing I learned through Schoolhouse Rock. Process, it's not a complicated concept. And I think about the origins of requiring due process in America. Remember, so many things of our Constitution were values that the framers wanted to incorporate that were not recognized by the king. And part of the commitment that the framers of the Constitution had was like, look at all these lists of tyrannical behaviors that we have been subjected to.
Mhm.
And we are going to make sure we do not commit the sins of the King of England. We're going to be different. And, one of those sins was not providing people an opportunity to defend themselves. If you were accused of something and the king was convinced that you did said thing, you could be beheaded or you could be, locked away without kind of any process. And so what we're seeing now is this lack of process that feels very un-American. And I think that's part of what's
Mhm.
jarring for folks. And before we can even get to, and there's I'm going to make a connection to a jury piece, but before we can even get to the integrity of the allegations, we as Americans are concerned with the fairness of the process. And I want to connect that to our conversations about juries, right? We all want to live in a safe city, wherever that city might be.
Mm.
And I think at some level, we all believe in different versions of accountability. Right. Right now, we're using a system of incarceration as accountability, which isn't one that I think works and is not one that we deserve. But the premise and the concept of accountability is something that, almost everybody gets behind. If we were to see an all-white jury and we were to see a black defendant, or if we were to see an all-black jury and a white defendant, before we would be able to have a conversation about the substance of the accusations, we would criticize the fairness of the process.
Mhm.
Because that jury, that homogenous jury, that same looking jury, is not necessarily the proxy for fairness that we are accustomed to from a democratic sense of representativeness. I saw a cartoon where there was a dog on trial and the jury was all cats. Right? It's like, well, of course, 12 cats. But I want to talk about process from a constitutional perspective, right? There's due process, and there's two different types of due process. I want you to handle procedural due process. I'm going to take substantive due process. But can you start with procedural due process and just explain for us, like, what does that mean? What does that look like?
Absolutely. So, for the individuals that are out there that are not lawyers, in order for the government to take away life, liberty, or property, right? So, we're talking about death, right? We're talking about jail, and we're talking about property. Now, I'm not just talking about land, right? I'm talking about anything that you have a property right in. So, for example, if you receive public assistance from the government, that is a property right. If you have a driver's license, that is a property right. If you have health care, right, that is a property right. And in order for the government to take away life, liberty, or property, they have to follow the proper procedures. And that is notice and an opportunity to be heard. Now, what that looks like, right, to just in layman's terms, is essentially if you are accused of a crime, right, and your liberty or your life is in jeopardy, then the government has to tell you what you are accused of, right? And give you the opportunity to answer to those charges, right? And so that's when, for example, across the country here in America, we have what's called an arraignment. That arraignment is the opportunity where you find out what the government is charging you with, right? And that arraignment is your opportunity to plead guilty or not guilty. And now, don't get me wrong, that arraignment will not be the last time you have the opportunity to do that. That's also why we have criminal trials, right? Additionally, when we're talking in civil terms, right? Those public benefits, right? The government also has to tell you, right, that they are taking away your property rights for X, Y, and Z reason. And they have to give you an opportunity to answer for those things. That's why we receive those notices from the DMV. Your license is being suspended for X, Y, and Z. You must appear on X, Y, and Z date. How'd I do, Will?
I'll give you an A+ on my exam.
Hey, hey.
And and my students just took my con law exam on Monday, and there was a procedural due process issue. And this stuff is just fresh in my mind. So if I have
Mhm.
permission to add a couple of things, I want to. So you're
Please and
talking about these property interests, these property rights, and some of the cases that you reference. Like one case is called Goldberg versus Kelly, which was a case
Mhm.
about I think it was welfare benefit, and then Matthews versus Eldridge was a case
Yeah.
about Social Security disability. And then there's this conversation in these cases about, well, does the notice of this, this property interest or this property right being taken away, do you have to have this opportunity to be heard? Do you have to have this hearing before it is taken away or after it is taken away? Is it a
Right.
pre-termination hearing or is it a post-termination hearing? And the court has recognized something like welfare, something that is, sustaining people's livelihood. You got to have a hearing before it gets taken away. But something like Social Security disability, since that's not the only type of benefit that the government offers people, the Supreme Court has recognized that taking that property interest away before you have your hearing and that the hearing is happening after the deprivation, that is in fact okay. How would procedural due process look like? Well, let me ask you this. Does procedural due process only apply to United States citizens?
No.
It does not. So it applies to people in our country. So how would we expect a procedural due process to be carried out for undocumented people instead of just snatching them off of the street and then throwing them on planes and deporting them to countries that they've never?
You mean what's happening now, right? So before our government decided to start just kidnapping folks without any process, what could happen is an individual have an opportunity to explain why they have come into this country and been given an opportunity, right, to speak to a judge about who they are, what they experienced in their country. That's one way, right? Particularly for individuals that came here not on a visa, individuals who did not marry a United States citizen, or individuals who, for example, and actually I want to stay on the visa for 1 second. So individuals who are here on work visas or student visas, right, or even vacation visas, right, if they have overstayed those visas, they could have an opportunity to explain to the government why they overstayed those visas. And there are several reasons why an individual may want to come here instead of being in their home country. And most people think about of persecution. And the individual, like I said, would have the opportunity to explain to a judge why they should be allowed to remain in this country. The other way is that they come here on a visa and they apply when they get here immediately, and they have the opportunity to do what's called naturalizing. You apply, you go through the process and become a citizen. What's happening now is that people are not even seeing judges or having opportunities to state why they should be allowed to stay here.
Thanks for breaking that down. What's concerning for me is that there's this expectation, and I think I've heard people of different political persuasions than myself talk about, well, we expect people to follow a process, like you apply to come into our country, and like you go through the appropriate procedures. And when I had the opportunity to go to Tijuana, and I had a conversation with a lot of the migrants that I was speaking to were actually from Cameroon and from Haiti. They said that the app that they were using didn't it was like a digital app on the phone, and you have to do like a face scan. It didn't recognize their facial features, right? Because they were dark skinned. And so they were trying to go through the process and it wasn't working. And so for me, there's a little bit of hypocrisy here. We want people to follow a process when they're coming into our country, but we as a government aren't administering a process to consider whether or not they should be removed from our country. And when I have conversations with folks about the death penalty, and particularly when the death penalty is being applied to people who have committed murder, they say, well, this person didn't care about, whoever they killed, so why should the government care about them? It's like, because as a government, we don't need to necessarily replicate the behavior of people who we have, incarcerated or who we have convicted. And in fact, as a government, we should be modeling the type of behavior that we are expecting. And it's just really hypocritical to say these people aren't going through a process, so we're not going to provide them one. Procedural due process, you nailed it on the head. I just want to remind people that there's also something called substantive due process.
Mm-hmm.
And right now, what we're seeing and we're having conversations about is primarily procedural due process. So I'm only going to talk about substantive due process for 30 seconds. So the concept of substantive due process is interrogating what is the government's reason for depriving the person of this right? Like, do they have a justified reason why? And when we think about substantive due process, still applying to the infringement of those rights to life, liberty, or property, there are two different thresholds that the government has to survive in order to deprive a person of one of those three rights. The highest one is called a strict scrutiny analysis, and then the lower threshold is a rational basis analysis. And basically all that means for people tuning in that aren't familiar with that concept is if the government is trying to infringe a fundamental right. And when we think about fundamental rights, we typically look at history and traditions of the United States. We also look at the first 10 amendments. If the government is trying to infringe upon one of those fundamental rights, they have to survive strict scrutiny. But if they just want to infringe upon a non-fundamental right, like a case, for example, the Congress passed a law saying that if you wanted to get a new prescription for your glasses or you wanted to get new frames, that prescription had to be renewed by an actual eye doctor. It couldn't just be the optician that's working in the store. Now, that doesn't have anything to do with a fundamental right, but since it is a non-fundamental right, the government only has to survive a rational basis. So in instances of what we're talking about right now, in terms of what's happening in the country, substantive due process isn't the central conversation. Procedural due process is. But in terms of, just making sure we're giving everybody the full story, we want to recognize that there are two different types of due processes in America.
Absolutely. And before we move on to sort of talking about James Comey, for the folks that are out there, even though we have not explicitly stated that our government and these processes are often applied differently based on people's race, based on people's national origin, we do recognize that individuals that are experiencing an abrogation of their rights, it is often experienced more heavily by individuals that are Black and brown. In New York right now, it has been noted that ICE is primarily targeting folks they claim that are non-citizens that are Latino, right? Even though there are other people from other countries that could potentially be subject to ICE enforcement, primarily those that are being targeted are Black and brown. So I do not want y'all in the audience to think that we don't recognize that. We absolutely do.
Thanks for that. I need 1 second. My laptop's about to die. Hold on.
So while Will is gone, oh, he back. Well, I could have still kept talking, y'all. We didn't have his headphones on. Hey, Will.
All right. So I want to talk to you about your boy James Comey.
Why you gotta be my boy?
I'm just messing around. I know he's not the boy because he's like the top cop, right? Or he was.
You know he's not my boy.
So for those of you that don't know, James Comey used to be the FBI director, right? And he and Trump are anything but friends. And as you all have known, we have seen some politically motivated politically motivated prosecutions as it relates to President Trump essentially directing the Attorney General, Pam Bondi, to go after folks. And so one of the folks that are described as, Trump's political rivals has been this guy, James Comey, who was the FBI director. And they're trying to, this whole thing kind of kicked off with Trump sending out a tweet, which he meant to be a direct message to Pam Bondi saying, like, what happened? Like, what are we doing about James Comey and Letitia James and all these people that were, opposing me and trying to get me indicted and impeached and all this other stuff? Like, do something about it. Like, he's telling the Attorney General to do something. And so the Attorney General, Pam Bondi, instructs the U.S. Attorney in Virginia to go and indict James Comey. And the seasoned prosecutor in Virginia is like, hold on. Like, I'm looking at the case that we have here. There's nothing here. I'm not going to indict somebody for when there is no case. Before I keep going, how often do you think that happens? How often do you think a prosecutor says we're not going to indict because we don't have a case? Do you think that happens a lot, Porsha Shaf'on?
I know it doesn't. I am a criminal defense attorney in the Bronx. I know it doesn't.
It's rare, right? It's rare. So especially when you have the top prosecutor, like the U.S. attorney for that district in Virginia, who's saying, look, we don't have a case, so let's save ourselves the embarrassment of trying to bring false charges. The Attorney General, Pam Bondi, is like, look, if you don't bring these cases, you're going to have to resign. And so he signs his paperwork and he resigns. But this case against James Comey, it started, or at least what they're looking into, occurred on September 30th, 2020. Now, we might be thinking, well, why is that significant? Well, we have this thing called statute of limitations. And can you just remind the folks, what is the purpose of, or what are statute of limitations, and how does that play a role in criminal cases?
Yeah, so basically the government really cares deeply about finality, right? And so they
Mhm.
don't want to give people forever and ever and ever and a day to bring charges, to make complaints. So there is a time limit on when you can bring certain charges. And that is both in civil and in criminal cases. So whenever you hear statute of limitations, that's precisely what folks are talking about. The amount of time
Okay.
that the government has to bring certain charges, or the amount of time an individual has to file a complaint or start a lawsuit.
Thanks. And is it the same for every case, or does it vary depending on the type of case it is?
It varies
Like the type of
depending on the
like the
type of
like the
case it
type of
is.
crime, I mean, I'm sorry.
It varies. It varies depending on the type of crime.
Okay. So this crime, I don't remember the exact name of it, but James Comey is essentially being accused of lying to Congress. And that happened allegedly on September 30th, 2020. And for that crime, it's a 5-year time period. So that brings us to September 30th, 2025. And that's what kind of brings us, up to the radar, because the statute of limitations is about to run, meaning that once they get past September 30th, 2025, they cannot charge James Comey for that behavior that allegedly took on September 30th, 2020. So the U.S. attorney in Virginia resigned. He's like, I'm not going forward with this. So then AG Pam Bondi taps, I think this woman's name is Lindsay Halligan. She is not a prosecutor, never been a prosecutor, never talked about wanting to become a prosecutor. She gets tapped as an insurance attorney who used to be one of Trump's personal lawyers to now become the interim U.S. attorney in Virginia.
Also,
And she
because
makes
he
a,
said
she
she's
makes a
cutie patootie, Will.
according to who? I'm not
Trump.
going to
That's
get
what he
into it. So she goes into the wrong courtroom. She, does not follow the appropriate procedures of presenting a case for an indictment. And as a reminder, when you're presenting to the grand jury, essentially what you're trying to do is demonstrate that there's probable cause to convince the members of the grand jury that they should vote for probable cause to indict that person. So she's able to secure an indictment, which is a low threshold, right? And
You
that
can indict a ham
indictment,
sandwich.
but not the man who threw one, right?
That's right.
We
Hey, shout out to DC.
the federal judge gets this indictment. Is like, hold on, who is this? Like, who is this woman? She's not a U.S. attorney that has been appointed and confirmed by the Senate, right? There's a process for this. The Constitution, speaking of process, right? There's a process for this appointment to happen, and it has not been followed here. So the federal judge throws out that indictment and says the process that y'all followed was not constitutional, so this indictment is invalid. And that happens after the statute of limitations has ran. So that's the first issue. The second issue is, well, the first issue was you didn't really have a prosecutor running this thing. The second issue is the statute of limitations has run. And now I want to talk about this third issue. Between 2017 and 2020, there was a warrant that was signed to do some investigation into James Comey and his attorney. And we'll get to this in a second, but warrants are essentially authorizations for the government to invade your privacy, right? For probable cause, like for purposes of an investigation. But after they investigate James Comey and his attorney, the Department of Justice finds that there was no wrongdoing, that there was no crime, and no charges are brought. So they held on to the materials that they seized after 2020, which is a no-no, right? The warrant says you get to look at this stuff, you get to access this stuff for this time period. But if you don't find anything that leads to investigation, you got to give it back. So just this last weekend on Saturday, a federal judge, James Comey's attorney sues the Department of Justice for violating his Fourth Amendment rights. An unreasonable search and seizure and kind of a maintaining of his files, and whatever evidence they were trying to use, which appears to be covered by attorney-client privilege, that evidence is going to be suppressed, and their whole case, even if they had one, is out the window. So I wanted to just kind of demonstrate that we have a level of incompetence that is being accepted that is unacceptable.
You
And when
think?
we are having prosecutions being motivated by, political rivalries, we are continuing to lose any integrity, if there was any, in our system of justice, right? And we don't say justice system because it's a system that lacks justice. But we had a question about the indictment, of whether or not it was a valid indictment. The answer is no. It was an invalid indictment because it was improperly secured by a person who was not actually the properly appointed attorney for the District of Virginia. So it was thrown out since the woman who sought the indictment was not actually a properly appointed U.S. attorney.
So for those of y'all that are out there, right? Like, did you catch what Will just said? So because homegirl was raggedy and walked into the wrong courtroom, did everything wrong from the door, the judge said that since you were raggedy, all the stuff that followed you was raggedy. So get up out of here. That right,
Mm-hmm.
Will?
Yeah, thank you for that translation.
You raggedy, your mama raggedy, all y'all out of here. So no, the indictment wasn't proper.
Exactly. They then try to seek a second indictment, right, against Letitia James, because the indictment against Letitia James and James Comey have both been thrown out. They try to seek a second indictment, and then the grand jury says, no, we are refusing to indict. So we as taxpayers need to be a little bit more concerned with how our money is being spent. And pursuing prosecutions in this manner really is kind of antithetical to being a proper steward of our taxpayer dollars, right? That money should be used appropriately, particularly when part of this administration was about financial efficiency, or I forgot what DOGE stands for, but it's a bunch of nonsense. And we think about, like, what is the cost to citizens, right?
That's right.
It is, to pursue prosecutions, right? For a grand jury presentment, you're paying the prosecutor's time, you're paying whatever, cost it is for compensation of the grand jurors for a particular time period, whatever court staff it's going to be in there providing the security. And then that's just a grand jury indictment presentation or request. From there, you're going to have, a ton of hearing dates. You're going to have an arraignment. You're going to have a pretrial conference. You might have a discovery hearing. You might have a preliminary examination. You might have a trial, right? So we're talking about a ton of different court hearings that's going to require the judge to be present. That's going to require different prosecutors to be present. And they're not only working on the case for those days in court. Theoretically, they should be working at the case when they're back in the office. So I don't have an exact amount, but it's costing significant amount of money at a time when we need to be focusing on things that are more invested in making sure that all Americans are in a space to thrive, right? Just the way that we're using money isn't getting us there.
But well, so in addition to, us being concerned about how our money is being spent, what about how government officials are behaving, right? When we
Mm,
when we're thinking about petty prosecutions, right? Literally behaving as if you are an individual in high school that is trying to get back at your op. Right?
yeah.
What message does that send to the country, to the people, when individuals that are in the highest offices are behaving like this?
It's as much as I disagree with a lot of laws in our country, I still have respect for them, right? And I respect the process of a judge being in a position to interpret and apply the law. And if I disagree with that judge, there's a process. I appeal, right? I don't go and disparage this judge and talk about, all these personal attacks on them, right? There is a system in which that have been accustomed to. But when we're seeing this petty prosecution, when we're seeing this frivolous behavior, it degrades the processes that we have had in our democracy that leads to a lack of integrity.
I was
And
waiting for
the
that
fact,
part.
yeah, uh, and it really erodes faith and confidence in our system. And maybe, hell, that might be part of the tactic, right? But it's really concerning for me as a law professor, right, to stand in front of a room full of 70 soon to be attorneys and talk about this process from this book called the Constitution. And then in the background, we have examples of the separation of powers not being respected and not being followed. And I shared this on the last live we had. I had the privilege of having a judge from South Africa come to my class. and he was appointed by Nelson Mandela, and Nelson Mandela, took some executive action, and then the court said, President Mandela, you can't do that. And then Mr. Mandela had a big news conference and said, listen, everybody, my attorneys thought we could do this, so this is why we did this. But the court has now said that this is actually not within the authorities of the president according to the Constitution. Thank you to the court for making sure we are being consistent with the Constitution. Like, this idea of deference to the court and their interpretation and application of the law has gone out the window in the United States of America. Not only because of the actions of the executive branch, but the actions of the judicial branch as well, right? So we have a lot of work to do. It erodes our trust in the system, and that's going to have long-term consequences.
Absolutely. Absolutely. Thank you so much for bringing us up to speed, both about, the processes that we are sort of witnessing every day in the news, and about my boy James Comey and how this petty prosecution is really falling apart at the seams.
It's embarrassing. It's embarrassing.
Absolutely.
I'm not, never will be, never thought about being a prosecutor, right? But it's embarrassing as somebody who, at the end of the day, I can respect a system that has been designed to allow for a system of checks and balances, and to approach prosecutions in this way against political rivals is just, it's really disappointing.
Absolutely. Absolutely.
So we got this Fourth Amendment piece, right? Remind me a little bit more. What does the Fourth Amendment stand for, and how does that relate to warrants, and what's the process of getting a warrant?
All right, members of the jury, let's break it down so it can forever and consistently be broke, right? So we have multiple constitutional rights. The Fourth Amendment specifically protects us from unreasonable searches and seizures in all places that we have an expectation of privacy from government actors, right? And what makes a search or a seizure reasonable, right? It is when a government actor, right? That's police, that's ICE agents, that's individuals that are government actors that are supposed to follow the proper procedures and processes, right? Those individuals, in order to search or seize you, have to have a warrant. They have to have a warrant signed by a judge, and that warrant must be based on probable cause. Now, remember from my last live class, right? Probable cause is when there is a fair probability that the place to be searched or the thing to be seized, right, contains the fruits of a crime. That is what makes a search or a seizure reasonable by government actors. And that warrant, right, that is based on probable cause must be signed by a judge. You muted, Will. You schooling me on mute? Okay, there you go.
Does a warrant have to, like, does it last forever, or does it have like an end period? Like, once the
Absolutely not.
government gets a warrant, how long does that authority last?
It depends. I can tell you here in the Bronx, when police officers get warrants from judges after lying to them, they normally only have 10 days to execute that arrest warrant or search warrant.
Yeah, I think that's pretty consistent. And I'm thinking about a United States Supreme Court case called U.S. v. Jones, where federal prosecutors, federal law enforcement got a warrant to put a GPS tracker on a person's, I think it was a Jeep Grand Cherokee. And then on the 11th day, they go and they put the tracker on, and they use all this information. And Justice Scalia writes the opinion. He goes, look, you had authority for this 10-day window. Like, you don't get to use the information that's collected on the 11th day. So warrants are not a continuous and ongoing permission to infringe upon our Fourth Amendment protections against unreasonable searches and seizures. And I bring that up because in the case where we're talking about with James Comey's attorney, right, they had a warrant in 2017 and 2020 to look at the computer files, but they did not have a warrant today. And that's a big problem that they have. I want to talk about the Fifth Amendment too, because I think that's going to connect to our conversations about Luigi Mangione. So what is the Fifth Amendment, and what are some of the rights that we associate with the Fifth Amendment?
Well, one of the most important, Will, for those of you that follow us, Will did a video on this that's called Shut the Fuck Up, right? You have a right to shut the fuck up. So the Fifth Amendment protects us from ourselves. It protects us from incriminating statements, right? Self-incriminating statements. Now, I know many people out there watch Law and Order. I know many people out there watch these shows where the police officers slap the cuffs on you and then immediately read you your Miranda rights. Members of the jury, break it down so it can forever and consistently be broke. There is only one instance, hear me, one instance when the government officials have to read you your Miranda rights. When you are in custody and you are being interrogated. Both of those have to be present at the same time in order to activate the police's requirement to read you your Miranda rights. Let's run it back. In order for your Miranda rights to be acted, fuck a Law and Order. I don't care what you see on TV. I don't care what you see in the movies. Under our Constitution, in order for your Miranda rights to be activated, you must both be in custody and be subject to interrogation. Both of those. If the police officers cuff you and don't ask you nothing, no Miranda rights. If the police officers are only asking you questions that have to do with biography, no Miranda rights, right? Both of these have to be true. If the police officers start asking you questions and you are not in custody, no Miranda rights. Please, please, please remember, both of those have to be present. Now, the idea of custody has been litigated through and through and through and through and through and through and through, right? When you are in custody, it is when you don't feel like you have the freedom to leave. Now, you do not have to be in handcuffs. Will, please correct me if I'm wrong. You do not have to be in handcuffs in order to be in custody. If there is a police officer gunned out, tasered out, right? Not out, but if they have all of this stuff on them, one is standing in front of you, one is standing behind you. A reasonable person would not feel free to leave, right? If you are in a bedroom and a police officer is standing in front of the only exit point in the bedroom, a reasonable person would not feel free to leave. Law Professor William Snowden, how did I do?
Again, A's across the board, right? So we're thinking about custody and interrogation. Custody, as Porsha Shaf'on has said, there's this reasonable person standard. Like, would a reasonable person believe that they would be free to leave? But who the hell is a reasonable person? I don't know. But sometimes you can ask.
Yes.
you can ask, like, am I free to go? And if they say no,
That's right.
you are in custody. And you're absolutely right. You don't have to be in handcuffs. You don't have to be in zip ties. You don't have to be in the back of the police car. But if you are in those things, you are definitely going to be in custody. And then when it comes to interrogation, right? When they're asking you questions that a reasonable officer should know is going to be that the answer is likely going to be an incriminating answer, that is interrogation. But if they're just asking your name, and kind of like those very, like you described, biographical background questions, that's not interrogation. But if they ask you, like, where are you coming from? And you say, I just came from this bank, and they know that the bank was just robbed, like that's incriminating information. That is interrogation. And so we're looking for both of those things to be present. Are you in custody? Meaning, are you in a space where a reasonable person, or you don't feel free to leave? And then are you also being asked questions that the answers could be used against you because they're incriminating in some way? Before they can do those two things, or when you are in that situation of custody and you're being asked these questions and you're being interrogated, as Porsha Shaf'on has indicated, that's when they have to give you your Miranda rights.
Absolutely. Now, we talked about the Fourth Amendment. We talked about the Fifth Amendment. We need to run it back to the Fourth Amendment real quick. Professor Snowden, are there any exceptions to this warrant requirement?
So many. There's so many exceptions. We got exigent circumstances. We got medical emergencies. We got, all types of exceptions to this warrant
Search
requirement.
incident to lawful arrest, the automobile exception.
SELA, yeah,
There,
all that
yes.
stuff.
Yes, there are multiple exceptions. So I wanted to make sure, members of the jury, that you understood that while under the Fourth Amendment, under our Constitution, these government agents, right, these police have to have a warrant to search or to seize you. There are also exceptions to this warrant requirement. And oftentimes when you see people arrested on the street, it is without a warrant, right?
Mhm.
And the police have to make sure that if they are arresting you, right, without a warrant, that their behavior fits in to one of the exceptions. That right,
That's
Professor
right.
Snowden? Perfect.
It
We
is.
actually, oh, I'm
Um,
sorry.
mhm,
Go ahead.
you got it. I was going to say the same question, or just read off the question that we got. Like, how
Hmm.
do we know if the answer that you are providing is incriminating? And the good thing is you don't have to know that. It is the officer who
Yes.
should know whether or not their question is likely to elicit an incriminating answer. And the reason why you don't need to know that is because you're going to shut the hell up. Like, you just not answer questions. Like, you don't have to worry about if your answer is or is not incriminating, because guess what you're doing? You're not talking, right? And, when you say, I want an attorney, they have to do this thing that's called scrupulously honor, right? I don't know what type of honors there are, but a scrupulously honor is a pretty high honor. Like that, you got to give that honor a ton of deference, right? If you say I want an attorney, they can't ask you any more questions. Like, if you invoke your right to an attorney, you invoke your right to remain silent, they cannot ask you any more questions unless you reinitiate a conversation with the police, which you're not going to do because you're not talking, right? But if you're thinking about from a police officer's perspective, if a police officer is asking you a question that ties you to, a crime or a place where a crime was committed, or anything that could be that has some type of evidentiary value to show or to be used to be shown that you committed a crime, that's going to be incriminating. So the perspective is through the lens of the officer, because they are the ones who are doing the investigation, and they are the ones who should know that a type of answer should elicit an incriminating response. So the burden and the onus or the perspective is actually on them, not on the person that's being asked the question.
Absolutely. So, members of the jury, what have we learned today? When the police ask you, is that your crack? That is a question designed to get an incriminated answer. When the police officer says, oh, is that your gun? That is a question designed to elicit an incriminating answer. And what are you going to do? Shut the hell up. I said fuck, but I meant hell. You see how I be remixing Will's words? My
But
bad,
I
y'all.
actually, no, I like that. Like, we should just do a whole question and answer, right? Like, what's your
Absolutely.
name? What's your name? Not incriminating. How old are you? Not incriminating. Do you have a gun on you? Incriminating. Like all those
Like,
examples.
yes.
No, I like that.
But that is how
But
we
we
know
got
members of the jury.
So we have the Fourth Amendment kind of warrant requirement, and then you acknowledge that we have a ton of warrant exceptions. In the Fifth Amendment, we do have a concept called due process in the Fifth Amendment as it applies to the federal government, but we also have this concept of a right to not incriminate yourself. And we get these Miranda warnings, which comes from a case called Miranda versus Arizona. It's the right to remain silent. It's being advised that anything you say can and will be used against you. And then you have this additional right, which is a right to an attorney. And then if you can't afford an attorney, one will be provided for you for the purposes of that interrogation, right? And the Fifth Amendment right to an attorney is different than your Sixth Amendment right to the attorney, but it can be the same person. But from a constitutional perspective, we would just want to recognize that the Miranda warnings are specifically talking about the attorney for the purposes of that custodial interrogation, right? So you are provided these rights because the framers of the Constitution wanted to protect the people in our country from the government abusing its power against its people, right? And we think about these scenarios and these protections in the Fourth Amendment as it relates to the warrant, and the Fifth Amendment as it relates to protections against self-incrimination. Have any of these or either of these issues presented themselves in Luigi Mangioni's case?
They have. But Will, before we talk about Luigi Mangione, I just have to ask you one question about self-incrimination. Okay.
Okay.
In order to In order to note that you intend to remain silent, how must you do it?
You can just remain silent.
No, you have to say, I'm going to remain silent. It is the weirdest thing ever. You have to say, I am going to remain silent, because otherwise they're going to keep asking you questions, bothering you.
Oh, I see
So
what
the
you're saying.
easiest way to back them up off of you, officers, I'm going to remain silent.
And I guess I approach it a little differently. I just say I want my attorney, and by saying I
That's,
want
I
my
mean,
attorney,
more important,
that works
more
too,
important.
right?
Yes.
Um, to add to that, I think courts have interpreted a person. Well, actually, I don't know about that. I'm not going to finish that statement. But yeah, like if you want to invoke your rights, what I'm hearing is we have to be explicit.
Absolutely. And by being explicit, you have to literally say, I want my attorney. It can't be, as they said in New Orleans, I want a lawyer, dog. It has to be,
Man,
I know,
listen,
I know, I know, I know. I knew that was going to get a rise out of
the
you. I know.
dis the disrespect to our vernacular, right? So
Super disrespect.
listen, if I said so, let me give some context. The Louisiana Supreme. So there was a client
I've
that
been
we
waiting
had
for
for
Will.
the
I
public
was waiting
defender's
to
office.
shoot this off. I was waiting for Will. Gay.
When I was at the public defender's office in New Orleans, there was a client that I actually think our chief defender represented, um, who, when was arrested, said, "I want a lawyer, dog." Right, and that was his invocation of his right to an attorney. Now,
Chef's
if I
kiss.
were right, if this were a white man and the white man said, "I want my lawyer, buddy," or if it was a different person, they said, I want my lawyer, my guy," like that little add on, right? It is not a detraction from the invocation.
That's right.
These people on the Louisiana Supreme Court said that since there is no such thing as a lawyer dog, like how we have a canine, that was not an invocation of the right to an attorney. Now everybody knows that it was I want a lawyer, comma dog,
Dog.
DOG if you want, right? It wasn't I want a lawyer dog without the comma.
Yeah.
And the fact that a court would not recognize that as an invocation of your right to an attorney is really just kind of disrespectful to how we have so many different types of beautiful languages within the English language, right? We think about African American vernacular English, right? It was just really offensive, and unfortunately, that since that was not deemed an invocation, any statement that was taken after that was actually admissible.
That's right. That's right. I was waiting to let that gun off. I was like, ooh, I know how to get him going.
So frustrating.
It is maddening. And that actually brings us back to one of the things that we said, right? Which is that while we didn't state it explicitly earlier, that these laws are often applied differently to people of color. That's just one very prime example on what it looks like, right? When when there's an interpretation for an individual that's Black or brown. Luigi Mangione. His hearing has started in New York. And there are two things that have come up, which is why members of the jury, in the time that we have left, I'm just going to quickly summarize what the two things are to illustrate the points that we've already made as it pertains to the Fourth Amendment and any exceptions, as well as the Fifth Amendment. So there were two things that happened when Luigi was arrested. One of them was a search of Luigi's backpack. Now, remember, I'm going to remind y'all again that we as citizens under the Fourth Amendment are protected from unreasonable searches and seizures. And that means that in order for a search or seizure to be reasonable, the police have to have a warrant. In Luigi's case, when they searched his backpack, they did not have a warrant. So the Luigi's lawyers are saying that this search was an unreasonable search. It was a violation of Luigi's Fourth Amendment right because they searched his backpack without a warrant. The government is saying that they didn't need a warrant, that the search of Luigi's backpack fell under one of the exceptions to the warrant requirements, and that is search incident to lawful arrest.
Now, aren't there restrictions like distance restrictions in terms of where the government can search? So, like if I'm getting arrested, I thought that they only can search what's called as like the grab
Wing
area,
screen.
right?
Mhm.
Like what can I have access to? And that rule is rooted in a concept of officer safety, right? So like if there is a gun in my bag that's right down by my feet, from an officer safety perspective, they're going to search anywhere where I might potentially be able to grab so that I don't use that on them. Was this backpack in his grab area?
So I actually, to be honest with you, I don't recall where exactly the backpack was. But the interesting piece about the backpack situation is Luigi's lawyers are essentially saying that there was more than enough time, right? After Luigi was in custody to get a warrant to search his backpack. This was not a situation where they urgently needed to search his backpack right on the spot. They could have
So that exigent
arrested.
circumstance didn't
Correct.
apply. Gotcha.
Correct. And his lawyers are literally arguing that this is not a search incident to lawful arrest situation because it was a backpack, right? It was a place that Luigi had a reasonable expectation of privacy. Once he's handcuffed, he can't get to a weapon that could potentially harm officers. In addition to in addition to protecting officers, right? Caring about officer safety, our government is also incredibly rooted in protecting evidence, right? And preserving evidence. So not only do they not want to allow you to get into these items to get a weapon that can harm officers, they also don't want you to get to these items and you could potentially destroy evidence, right? So Luigi's lawyers are literally arguing with respect to the Fourth Amendment that these officers should not have searched his backpack and that their behavior does not fall within any one of the warrant exceptions, right? So the search of his backpack was unreasonable.
Got you. I'm hearing two kind of concerns. One is officer safety, one is preservation of evidence.
Yes.
And if I'm in handcuffs, probably behind my back, like I can't access things, right?
Hmm.
And then therefore the preservation. So the safety kind of component is no longer in consideration if I'm in custody and handcuffs, right? And then the ability to destroy evidence when I have my handcuffs behind my back, that's not really present either. So I appreciate your insight into these scenarios and into this case because I'm hearing both Fourth Amendment issues, and then I think there's probably some Fifth Amendment issues that might be for
Absolutely.
relevant conversation as well. And before you explain those, I do want to invite people to share some questions. If you have some questions, Portia's going to wrap up this Fifth Amendment piece, and then we want to hear any questions that you might have before we sign off at the top of the hour.
Absolutely. So, really quick with respect to the Fifth Amendment, right? So, the government is claiming that Luigi made statements. And again, right, running it back, if you are in custody and you are being asked incriminating statements, then the government must Mirandize you. What Luigi's lawyers are saying is that these statements that Luigi allegedly made were not Mirandized statements. Now, there's one final thing though that I do want to just add to the mix. Is when the government is also eliciting statements from you, it cannot be coercive, and that's a piece that we missed, right? It's important to note that the government can deprive you of sleep, can deprive you of food, of water, of using the bathroom in order to coerce you into making the statements. So when y'all are watching TV or y'all are hearing about these cases, just I want y'all to note that as well, is the government are not allowed to be aggressive and strong arm you into making an incriminating statement.
Thanks for that addition. We have a question that's going back to our conversation about being in custody. What do we do if the officer is aggressive, similar to how officers are being aggressive to immigrants? I have some thoughts. Curious to hear yours first.
So the one thing that I'd like to head note is to all you members of the jury. If you are in custody, there is nothing that you can say to get yourself out. So please don't say anything to the officers, because anything you say, like Will said, can be used against you. One other thing that I want to note specifically about the aggression of officers, one thing that you can say is, "Officer, I'm not resisting." And you can repeat that over and over and over again. "Officer, I am not resisting. Officer, I am not resisting." Oftentimes, when we watch some of these body worn camera videos, we will see these humongous officers standing on the backs or bodies of, individuals saying, "Stop resisting," when the individual is not even moving. So if you must speak, if you feel compelled to speak, don't. But if you must, please only say, "Officer, I am not resisting. Officer, I want a lawyer. Officer, I'm not resisting. Officer, I want a lawyer."
The other component to this good advice is more of a sad reality when it comes to like holding officers accountable for
Right.
improper kind of aggressive behavior like this. So you can sue police officers, and they're typically called like Section 1983 cases. The issue is that there is this shield and this protective mechanism called qualified immunity that creates a sense of immunity around officers not being held liable for their behavior when they actually are, mistreating people. And so to get like a lawsuit settlement with a police department for improper behavior, it's really, really, it's just a high bar. It's difficult to pass. It's not impossible, but if you are being mistreated and you are constantly saying, I'm not resisting, that's certainly going to help your case, and it helps paint the unreasonableness of the officer's behavior. And one of the things that the court looks at to apply immunity is whether or not the person was acting in their official capacity as a police officer. And then, is the behavior that was exhibited against you consistent with the police department's policies, practices, and procedures? And if it can be framed and positioned underneath the practices, policies, or procedures, then that immunity is going to apply. But if it is outside of those areas, then you have more of a chance of being able to, have a settlement or have a judgment. But when it comes to like monetary damages, and nobody asked for this, but like the 11th Amendment says you can't sue government actors in federal court. And if you want, there's two ways in which you could sue somebody, a government actor. One is called, you sue them in their official capacity for what's called injunctive relief, meaning you're trying to get a policy or a practice or procedure to stop. So, for example, the Los Angeles Police Department, in a case called, the person's last name was Lyons, sues LAPD because they put him in a chokehold and he was injured as a result of it. That case was thrown out because from a standing technical issue, he was unable to show the likelihood of future harm, meaning that the court was only going to grant his case if he could demonstrate that this was a consistent pattern, practice, policy of the police department. And yes, he's been injured in that instance, but there also needs to be a likelihood that he will be injured in the future. So one way you can sue government officials is in their official capacity for injunctive relief. That means you're going to try to stop something from happening. The other way in which you can sue government actors is in their personal capacity. And that's where you're going to get the money. You're going to sue them for their personal assets. So when you're going for damages, you sue them in their personal capacity.
Awesome. Thank you, Will. Members of the jury, I know that we did more of a know your rightsy live to end things off than we normally do. But as Will always says, an informed citizen is an informed juror. And we really want to make sure that, we give context to a lot of these sort of chaos that you're witnessing right now, right? And so it was really important for us to let each and every one of you know sort of, what it is you're seeing, and to really add some meat and potatoes to what it is that we're seeing. Take it home, Will.
As I kick things off, right, this is the 12th month of the year, and we've been doing these jury duty unmasked conversations throughout the year. And one of the things we'd love to hear from you, are there topics that you would like us to cover, right? Between the two of us, we just have a wealth of knowledge, both as it relates to things within our criminal legal system, as it relates to juries, but even things beyond that. So we want to make sure we are informing you, right? Because as Porsha just mentioned, we know that an informed citizen is an informed juror, and we want y'all to be as informed as possible, particularly in 2026 when things are going to continue as they are right now, and test us in ways that we haven't been tested before. I want to thank you all for joining us throughout the year, for joining us this evening. Let us know what other information we can share with you all to be prepared for future conversations. And I want to wish you all the happy holidays, and we'll see you in the new year.
Happy holidays. Bye-bye.
Bye. Bye.